A very good morning, everyone, and welcome to the day 2 of India ADR week in Mumbai. We have the first session by FTI Consulting on India's unprecedented ascent, managing legal and economic risks in a changing world order. On the panel, we have Mr. Karthik Balisagar, Senior Managing Director at FTI Consulting, Ms. Shanelle Irani, Senior Associate at Wilmer Hale, Ms. Priyanka Shetty, Partner at AZB and Partners, Mr. Sudhanshu Swaroop KC, Barrister at 20 Essex, Mr. Vikram Nair, Partner at Raja and Tan, and Ms. Shreya Jain, Partner at Shardula Mission Mangalas.
Thank you, Chavi. We have an unusual topic for an arbitration conference. As part of FTI Consulting, I'm a damages expert and can speak on damages, but also I deal with economics and accounting, and I thought we'll talk about India's ascent and what it means for the country, what it means for disputes, what it means for trade, and where does India sit in the geopolitical, macroeconomic landscape today. India is not only doing well, it's doing well in the backdrop of a changing world order. And that's what makes it even more special. I have a stellar panel today. I'll just probably spend less than a minute or so, and I'll request them to briefly introduce themselves. Shanelle.
Hi, good morning. My name is Shanelle Irani, and I'm a senior associate with Wilmer Hale in London. My practice focuses on international commercial arbitration, but also some investment arbitration. I'm originally from here, from Mumbai, and I've worked in Dubai and London for the past almost decade.
Hello, good morning, everyone. I am a barrister and King's Counsel practicing from 20 Essex Chambers in London. I practice international arbitration, commercial litigation, and public international law, including investment arbitration. I'm also co-chair of the Combat India Committee, and I've done and do various kinds of work, both public international and general commercial, related to India.
Well, hi, a very good morning to you all. I am Priyanka Shetty, a partner at the dispute resolution team at AZB and Partners. While I am seated in Mumbai, I'm fortunate that work has taken me all around. Primarily international arbitrations. We also dabble into investment treaty arbitrations where we can.
Good morning, everyone. My name is Shreya Jain. I'm a partner at SAM in Mumbai. Like most of this panel, my practice also focuses on domestic, international arbitrations and related litigations. Before working in Bombay, I was working in New York, also in the same field. Besides sort of, the topics we are discussing, I'm very passionate about diversity in arbitration and try to regularly write and speak on it. I'm a co-chair of I'm an India co-chair of the Young ITA. I'm involved with the LCI's Under 40 group and also an editor of the Kluba arbitration blog. So if I can encourage those of you who are here to contribute more towards what we try to do at the blog, we'll really welcome it. Yeah.
Hi, I'm Vikram Nair. I'm the Deputy Head of Dispute Resolution at Raja and Tan. We have probably the largest practice in Singapore and Southeast Asia, both for disputes and general legal work. We have about 1,000 lawyers now, which is quite big in a small neighborhood. And our disputes team, we do equal parts litigation and arbitration, and that's also my practice. So I'm a trial lawyer, appellate lawyer, but I also do a lot of international arbitration. And for several years, about half of my work anyway would come from India-related disputes, but usually arbitrations in Singapore. I don't do any arbitration seated in India. For that, we've got plenty of friends who do that. And yeah, look forward to this panel. Thank you.
Thank you, Vikram. And he's being very modest. He's also a sitting member of the Parliament of Singapore. And it is important to know your views on topic today, and I'll come back to you in 10 minutes, I hope. So the format is I'm going to present for 10 minutes on the geopolitical / macroeconomic picture, and then go into the panelists and ask them questions as to what it means for trade and disputes. So with that, I'll start off the slides. So I presented this chart about 2 years ago, about 2 years ago, to a strategic group of lawyers at a London law firm. And I don't know whether it is causation or correlation, but if you look at inflation increases in history, in recent history, you always had some sort of crisis, ideally, most likely a situation of war, starting around the peak of inflations. Now again, I'm not saying inflation is a cause for war, but Ukraine war was already on by that time, but what we're seeing in Middle East wasn't. And if you see the recent peak we had around 2020, 21, and then what's happening today in the world, it sort of broadly paints a picture. The question is, why are we here from a macroeconomic standpoint? And it's really important to understand where US sits in the whole canvas. So if you look at the richest nations, right, they're called G7, a group of 7. And if you look at the deficit, the average deficit between 1970 and 2008, the average deficit was about 3.1%. And that means basically between your assets and liabilities of the national balance sheet, there was a difference of 3.1%. That has shot up to 8.7%. This world order, as we know today, US-centric world order, for the last 200 odd years, is about to change, or at least be challenged. One of the factors, one of the forces among the 3 forces, and I'll talk about the other 2 forces shortly, is a weakening balance sheet of the West. And that's factor number 1. Why is it weakening? An obvious answer. Look at that graph, right? This is the debt, public debt, private debt of G7 nation. The blue line represents the GDP. If you look at the government debt after 2008, it has significantly shot up. And if you look at the GDP, it is almost flatlined. If you look at private debt, again, there's a significant increase. Now, debt in itself is not bad, but debt with a backdrop of low productivity and generating low national income is dangerous. And this is not the first time. If you go back in history, there have been cycles. It happened with the Dutch in 1700s. It happened with the British later. And today we are seeing the same issue coming up with the US. So it's increasing, a weakening balance sheet, huge increases in debt. And what does debt do? And as I said, debt is not bad in and of itself, but if it's not deployed properly, it's an issue. If you look at the GDP growth rate, a global GDP growth rate, largely driven by the G7 and China, it was about 8% until 2006, 2008. But if it's, again, after 2008 until 2020, 2021, it's almost flatlined at 3%. There's a significant drop in economic activity and a significant increase in public debt. And the biggest issue that is coming out is wealth distribution problem. Debt, when you don't have good productivity and good generation of national income, it benefits only 2 sectors. The first sector is the financial sector and the equity markets and the related markets, and the second one is the real estate sector. And I've just plotted this graph. Again, the second graph, if you see, that's the MSCI World Index and Dow Jones. You see the increase. It was 6% until 2008, and it shot up since 2008 to about 9%, depends which index you take. Actually, if you take S&P, it's much higher today. It's all-time high today. So it went and created a lot of asset bubbles because it was not being used properly, the significant increase in debt. And what happens if real estate sector and financial sector increases in the backdrop of huge debt and flatline GDP? You have an issue, which is the third force I'm talking about. You have an issue of internal conflict. You're creating a wealth distribution problem amongst your people, so there's more haves and have-nots, and that leads to populism of the left and populism of the right, and that's exactly what we're seeing in the world today. We all know what's happening with the US elections, and the energy levels are really high, but it's also extreme in terms of the populism, and that's dangerous. And if you look at this is a slightly dated chart, and this talks about political polarization in the developed world. You see the red line, which is the United States, it's at an all-time high. We hope it settles down soon, but it looks like it won't. And if you look at other countries, we have the same problem in Western Europe. And you've read the headlines these days, so one needs to understand this in the backdrop of what's happening to the economy and what's happening to the public debt system in these countries. It's an aging demography. So there are three forces, right? You have a weakening balance sheet, you have an internal conflict, and then you have the rise of debt, and this is creating a massive problem with these economies. And then you have the last force of rising China as a potential threat to the existing world order. There's no right or wrong. I'm not making an assertion here. All I'm saying is the world order as we knew that lasted for 200 to 250 years is being challenged. There's no good or bad, right or wrong here. We have a global south. We have countries like India rising up, and this is going to challenge the existing world order as we have seen it. Now, against this backdrop, where does capital flow? One needs to understand, where does capital flow? Capital generally flows. There are 5 factors that investors consider. A strong fiscal position, that means you have an increasing surplus or a reducing fiscal deficit. That's not happening in the West. I've just shown you the charts. A young working population. I can ask, how young is the average India age? It is median is about 28 years, as opposed to the US being 38, China being 44. And India is predicted to be around 40, even at 2050. So we have a very young and thriving population. There's rule of law, a stable government, and neutral geopolitical position on controversial issues. If you take those 5 factors together, there are only 3 regions that pop up on your world map today. It's the GCC region, it's Singapore, and it's India. And amongst those, if you look at India, it is the only fastest large growing economy. So when people say India is doing well, India is doing extremely well relative to other countries because of these factors, and that needs to be understood. And I'm trying to put that in light. And this is amazing. This chart is amazing. Yesterday I had, Nish was saying, look how far we have come. And this is the chart that I love. It took 60 years to achieve the first trillion, right, in terms of GDP. It took only 7 years to achieve the second trillion. And the third trillion came in another 7 years, but that is despite COVID. And we are expected to hit 4 trillion by turn of 2025, and about 7 trillion by turn of this decade. That is unprecedented growth. That's never happened in the past other than China. And at least for the for other economies like Japan and Germany, which are number 4, number 5, are almost now shrinking. So that is something which is unprecedented in terms of growth. I've already spoken about this. I'll skip this. This is about the demographics. We are so blessed to have 28 years as an average age, and it's only going to be 43 in 2070, as opposed to the other countries. If you look at it, the other large economies, they're already at 38, 40, and China is going to have an aging problem at 55 in 2070. Let's hope that that is answered adequately. So I won't spend too many, I've got a lot of things going on. People talk about infrastructure investments in the Middle East, and that's great. But look at India. We had planned infrastructure, committed infrastructure into construction projects of $1.3 trillion. And that's just unprecedented. And this was supposed to be, started to execute before 2025. That's phase 1. So the amount of economic activity that comes from these factors is just unprecedented again. And this means trade agreements, this means inbound investments become important, and therefore there's a lot more work for people in this room. So with this backdrop, I will now go to my panelists. I'll request Vikram to open. And the question I have is, how do you see this change in world order and the geopolitical situation, macroeconomic play, and how do you see from where you sit in Singapore in terms of trade and negotiations?
Okay. Thank you, Karthik. And that was a very interesting backdrop, I think, quick run through of economic and political history, both of which are closely intertwined. Singapore's history is relatively young. I think as an independent nation, we're just about 60 years old. And some of the interesting figures I will add to, I think, Karthik's presentation, because there's been a lot of talk about, I think, world order and trade, right? So in terms of trade as a percentage of GDP, just to put things in perspective, right? I think for the US, that number is around 27.36%, which means what they trade is about 27% of their GDP. For the UK, it's about 69.5%. For India, it's about 49%. Germany, around 99%. China, around 38%. Any guess on where Singapore would be? Yeah, we're at 336%. So trade is more than 3 times our GDP. I mean, we are a nation that lives and believes in free trade. And, the arguments against free trade are not new. About 100 years ago in the British Parliament, there was a politician and economist, David Ricardo. He was speaking up against agricultural protectionism at the time. And his idea was a very simple one, but one which almost all economists of both sides, both left and right, agree with. And that is the theory of comparative advantage. So at that time, his argument was England could do manufacturing and agriculture. It was quite good at both, but in relation to manufacturing, it had a significant comparative advantage over other countries. So it was actually best for the world if England focused on what it was relatively better at, which was manufacturing, and let the rest of the world develop in agriculture, because England had already invested a lot in industry. Its advantage in agriculture was much less. So this was an argument against protecting the agricultural sector so that resources could be allocated to manufacturing. And at that time, it wasn't a popular view, right? The more popular view was mercantilism, protecting your industries. You don't want to let an industry die. And this view has very strong political support as well, because, of course, if you're a farmer, you don't want to lose your lunch to someone far, far away. So this tension has been there for a long time, right? It's a debate that keeps reigniting itself. But most economists agree that based on the theory of comparative advantage, both sides would be better off if there was free trade, right? So one side focuses on agriculture, one side focuses on manufacturing, they trade, and overall, you will have more manufactured goods and more agricultural products. So this theory only became popular probably post-World War II, right, with the, what we call the Bretton Woods institutions, and also, of course, the General Agreement of Trade, Tariffs and Trade, which started the process of reducing tariffs and facilitating free trade. The World Trade Organization was a development from the General Agreement on Tariffs and Trade. So I would say that the prosperity the world has enjoyed over the last 100 years, post-World War II, or well, maybe 80 years, has been because of free trade, right? Because countries had more of an opportunity to focus on what they're good at, and generally more products were created in the world. Now, the chart that I think Karthik showed on India's economy is also interesting, because India's relationship with free trade was not always a very happy one, right? And I think, Mahatma Gandhi, even his view was we should do everything at home, right? Spinning wheels and so on, right? Why do we buy from England? So that's why it was an interesting chart where Karthik said it took 60 years for India to make the first trillion. Interestingly, India started opening up after that. So the next trillion came in 7 years, and the next trillion after that in another 7 years. So actually, India has also benefited a lot from free trade and from opening up. Now, in relation to Singapore, India and Singapore's, I think, more recent economic history goes back to 2005, where we had the Comprehensive Economic Cooperation Agreement. And this opened the door for both free trade, free movement of labor as well to a lesser extent. And in the 20 years since then, little Singapore has been India's largest source of foreign direct investment. I think something like 136 billion. Small for a big economy, but that shows, I guess, our commitment as well, right? So once the legal agreements are in place, the framework is open, investment flows. In terms of trade, we are a very small country, but in terms of ASEAN trade, we're about 27.3% of India's trade with ASEAN. So I think Singapore and India have had very close economic ties in the last 20 years, partly on the back of CECA. Unfortunately, in many places, this is not a fashionable view. So even in Singapore, we have political pressure. Our party, the ruling party, has come under pressure because of CECA, saying that we're giving Singaporean jobs to Indians because the Indian community in Singapore does very well. And these are pressures we have to deal with, right? The same arguments are probably happening in China, in the US, in the UK, because free trade allows some people to win more. For example, in the English case, it would have been the manufacturing group. But the people who are doing agriculture would have lost out, right? And that's the same thing when countries specialize and focus in areas. So I think the role of government then is actually to facilitate the reallocation of capital and labor. So in Singapore, we try to do that. We've had so many industries disrupted every 20 years. We were a huge manufacturing hub 60 years ago. Much of that manufacturing is now closed or changed, but we've had very strong relationships with the unions, and right now our new manufacturing is in the healthcare sector. So I think one of the biggest threats we face to the world order is exactly what Karthik has said, that free trade will become less fashionable, countries will become more insular, that is going to significantly reduce wealth generation in the world. For those who don't share this view, I think it's important for us to speak up, speak in favor of free trade, but also recognize its limitations and recognize that government has an important role to play in the reallocation of capital and to support those that may lose out from free trade when countries specialize. I can go on to this topic forever, but I should give other people some chance to speak.
Yeah, thank you, Vikram. So I'll move to Sudhanshu. An interesting comment, facilitate capital flow. What's been the UK experience of facilitating capital flow more recently, and what does it mean for India-UK trade partnership?
What I actually was proposing to talk on specifically was the was the Indian experience of BITs, and in that context, particularly the prospect of massively increased outward flows of investment. So the background is this: from the 1990s onwards, India entered a series of bilateral investment treaties with over 70 states. Under these treaties, the idea was that India and the other state would enter legally binding commitments to protect the investors of the other state, and there was to be an arbitration mechanism that would allow these investors to actually sue the states directly. Many of you will be familiar with that. The theory was that by entering these investment agreements, India would help to attract foreign investment. However, from the 1990s onwards, India started to find itself as a respondent state in many claims, some of them very high profile. I acted in for the government of India in one of the first of these claims, and these claims included, for example, the White Industries case. Roll forward to 2017, India introduced notices of termination for almost 60 of those investment treaties, and is now trying to renegotiate its treaties based on a model BIT which waters down the investment protection by, for example, narrowing the definition of investment. Moving on then to the issue of the future, my point is simply this: looking at the existing outflow of investment by Indian investors going into foreign countries, including the UK, and the prospect that that will increase even more in the future. When renegotiating these BITs, it is relevant, in my view, to consider these BITs, not just from the perspective of India as a potential respondent state to arbitrations, but also from the perspective of Indian investors as potential claimants against foreign states seeking to invoke the protection of those claims. And again, I say that having also acted in one of the first claims brought by an Indian investor against a foreign state. I was looking at the UNCTAD website, and this shows, at the moment, just 12 reported cases involving Indian investors against foreign states, including the UK. Pending claims include claims by Indian investors against Eastern European countries and African countries relating to investments concerning mining, railways, ports. These kinds of claims can run not just into the tens of millions or the hundreds of millions, but into billions of pounds. So just in conclusion, and I of course appreciate that renegotiating these treaties is very complex and a lot of interests have to be taken into account, but my narrow point is simply it would be consistent with this narrative of India as a rising power which is all about outward-bound investment as well as inward-bound investment, to take account of the interests of those Indian investors in these renegotiations.
Thank you, Sudhanshu. We all agree that India is shining, the economy is doing well, it's poised to do better. Free trade is important, we just heard that, and therefore protection of these investments through a BIT mechanism is also important, and it has a two-way mechanism, it's not one way. One of the key sectors that is important to all of them, and all of the participants in this room and the arbitration community is legal services, which has been much debated recently. So just pausing on this issue of legal services market, I did some research, and these are estimates, so I could be wrong. The legal services market in the UK is about 40 billion, which roughly translates into 1.6% of GDP. The legal services market in the US is about the same order. It's 1.6% of GDP. Again, these are developed economies. So I looked at developing economies such as Brazil and Mexico, and the legal services market there ranges, there are various estimates, but it ranges between 1 to 2% for Mexico and Brazil. When it comes to India, that statistic appears to be abysmal, at least going by what's available, publicly available. And that statistic is about 0.08% as a percent of GDP. For a thriving economy, for an economy as large as India, I'd like to understand from you, Priyanka, how do you see these statistics? Do you think there's something wrong in how it is measured, or there's something more to it?
Well, I think Karthik put it right. Hi, can you hear me now? So I think perhaps abysmal was the right word that you used, Karthik, because frankly, as an Indian lawyer, 0.08% is, to put it mildly, surprising if not shocking. Because we folks today are 1.25 million lawyers in India, which is roughly one lawyer for every 880 Indians on the ground. And we are not far away from the total number of lawyers in the US of A, which is around 1.35 million lawyers today in the US. And these are recorded numbers. Like Karthik pointed out, we are the 5th largest economy today, the largest population. And most importantly, we are also the 3rd largest economy today in terms of purchase power parity. And I mean, why not, right? Indians love to shop, whether it's clothes, gold, shares, and companies. If you look at the FDI inflows, India has witnessed a 20 times increase in its FDI inflow in the last 24 years. So that's roughly around $990 billion from 2000 to 2024. And if you look at the deal count in India, the last quarter of 24 was roughly 501 deals valued at $21.4 billion. The year before, I think India hit a record in terms of deal making with around 600 deals valued at $112 billion. 3 of the largest Asia Pacific M&A that closed last year had an India element. And not just India on perhaps, the buy side or the sell side. This was an out-and-out domestic Indian transaction with India both on the buy and the sell side. And, largely driven by us Indian lawyers. I think we have the statistics up there. So, in terms of where the Indian legal sector is today and where will it be tomorrow, I think, the thread follows the needle, and that squarely applies to the Indian legal sector as well. But what I am really most excited about is perhaps as an Indian lawyer to witness the development and growth of the arbitration sector in India. Because even today, a lot of arbitration is outbound in terms of seat outside India. LCIA, ICC, SIAC all recognize India as major players and users of their institutional rules. Forget the major arbitration institutions. Even the Finland arbitration institution, in 2022, out of the 80 cases, had 2 cases with Indian parties. With India and Indian parties being a significant player in international arbitrations today, how many of Indian arbitrators are really appointed in international arbitrations? Thanks to India Promise and my lovely team, we've actually crunched up a few numbers. I'll put it very shortly. We roughly have around 5,458 cases from 2021 till 2023 in the top 3 arbitration institutions today, of which, gentlemen and ladies, only 92 Indian arbitrators were appointed, which is roughly 1.68%.
That's really helpful, thank you. Shreya, given the activity level in India, both economic and, thank you Priyanka for all these statistics, it's illuminating. What should India do? Are there any reforms that India needs to embrace? And the famous question at arbitration conferences, can India be a hub for arbitration? Can you enlighten the audience, please?
I think we could go on for the entire India ADR week on this topic, but I want to focus just on really one small point, and I don't know if you have the slide.
Yeah.
Yeah, so this is a chart from the 2018 Queen Mary survey on the key considerations of choosing a seat. And really just focusing on a couple of them. The second one, you see efficiency of local court proceedings. The fourth one, track record in enforcing arbitration agreements and awards. Then the fifth one, national arbitration law. And then the second last one, neutrality and impartiality of the local legal system. All of them have just one theme, really, which is minimal court intervention and how the legal system treats arbitrations. And in the Indian context, and I think Priyanka touched upon this, we very often, even as disputes teams, advise our transactional colleagues to pick a seat outside India. And obviously what that means is that, you have an award and then you can go and enforce it, hopefully outside India, or you really don't have to face challenges in India. What you don't want to get stuck with is that you go through the process, get an award in 18 months, but then you get stuck in Indian courts for really like decades. But the problem is that as long as we keep advising that, and as long as we keep offshoring that work, we are really never going to become an arbitration hub ourselves. And therefore, a marquee aspect of any good seat of arbitration is 2 things. One is minimum court intervention, and second is quick disposal of any applications which come to court. That's really, I think, an area where concerted effort needs to be taken by all stakeholders to improve India as a seat of arbitration. Just this year, and I think the entire audience must be familiar with the Delhi Metro decision, which was a curative petition decision by the Indian Supreme Court, an arbitration award seated in India, which went through really 5 rounds of appeals till it got set aside by the Indian Supreme Court. That's a very disappointing precedent and will open gateway in interfering in domestic awards in future. That's going to court intervention, which we really need to overhaul as an approach. And the second point is quick disposal of any applications which do come before Indian courts. I was reading a couple of weeks ago that insofar as the Gift City initiative is concerned, it's being proposed that there will be a separate arbitration institution to deal with those disputes. But more importantly, they propose to have a separate bench of the Gujarat High Court, which would deal with all sort of appeals or applications which are coming from those arbitral awards. Of course, it's difficult to see, or it's sort of yet, we are yet to see how successful that will be in bringing by itself investments to Gift City, but perhaps that's an idea we can incorporate for the Indian legal system as a whole, that we have dedicated arbitration benches which are hearing these cases, as opposed to, a changing roster where just last week we came to know that one of sort of the Section 34s that our team is handling, which was pending for several months, is now going to be heard by a separate judge because the roster has changed and we are starting afresh. So these are just sort of practical everyday problems which are hampering India to get there as a hub of arbitration. And I think those are the factors that we need to tackle, because that will end up hitting 5 out of the 7 things we see on the seat.
Thank you, Shreya. Notwithstanding all the problems, right, we still have, yesterday and today, we had a room full of foreign delegates, foreign law firms. So definitely there's interest. And the elephant in the room is, will India open up its legal services market for foreign law firms to set up? We have representatives of 2 international law firms here, 2 Indian law firms, so the debate can go on forever. So I'll put the question in the barrister's hands. What do you think, Sudhanshu?
Well, I will just talk from the perspective of disputes. And in that regard, one has to, I think, be granular and consider which aspect of the disputes market are we talking about. If we're talking about domestic Indian court litigation, the day-to-day stuff that many of you will be involved with, I think there's a distinction between whether they should open up and whether, even if they do, it's going to make much difference. Because I do wonder how much interest foreign firms will have in terms of getting involved in domestic litigation. I think maybe arbitration, particularly international arbitration, is a different matter. And there is an interest there. But ultimately, I think in terms of answering the question of should, it boils down to 2 things. Service, i.e., if international firms come in, will it improve the quality of the service to Indian litigants? In theory, I suppose it ought to, because there would be increased competition. And secondly, cost. Will that service be at a reduced cost? On that question, I really don't know the economics, but I could see an argument that it might actually go the other way. So I'm really sitting on the fence here. Just one last observation I'd make about what I've seen in the London market goes to the point of reciprocity. What I am seeing, which I never saw even 10, 15 years ago, is a lot of very bright Indian qualified lawyers who are coming to London and working either for the top UK and indeed US London-based firms, or indeed in some of the top London barristers' chambers, London barristers' commercial chambers. So there is an argument, I think, around reciprocity that if that is happening, there should be something reciprocal happening over here.
Shanelle, do you want to add your international experience to this?
Thank you. Yeah, I will add just a couple of points. In terms of foreign firms coming in, I think that the BCI rules were already the first step in that, towards that. Obviously, the rules are not the clearest, and there may, in fact, the way they seem to be worded right now, it might just be easier to not actually come in and fly in and fly out. If India does, in my opinion, really want to become an international arbitration hub, I think that there has to be a way, an easier way for foreign law firms to come in and out, whether that is to set up an office, but just to fly in and out, like a 60-day aggregate rule to be present here is just too restrictive, for example. Agreed with Sudhanshu that nobody really wants to come in and maybe not to do litigation, which is, I think, what the worry is. And the rules can be clear on that as to what you can do and what you can't do. But as long as the rules are clear, I think that is definitely one step towards India becoming an arbitration hub. The other things we could do in terms of structural changes, which was your original question, is maybe come up with legislation regarding third-party funding, which, say, Singapore has, for example, Hong Kong, etc. It's not, people are not really sure what the situation is currently in India with regard to that. And the arbitration bar, for example, is a really good step towards bettering India and making it an arbitration hub. We hope that the arbitration bar does more in terms of promoting Indian lawyers, but also promoting arbitration generally outwardly when people look at India from the outside. Court interference, obviously, but judicial stability. Every time we go 2 steps forward, sometimes we always somehow come 1 step back. There's always the one judgment or the other. And then people are not sure, there's no stability. And if we can just keep that consistency for like 5 years, I think, India is definitely on its way, because there's no question about it. Your statistics said it. A lot of the work is coming out of here. And all we need to do is make a couple of changes, and I think that we can get there.
Okay, thank you. I mean, we're trying to weave a very broad topic here, so I'm going to quickly move to the next topic. So we started with the state of economy, macroeconomics, world order, why global trade is important, and backdrop of that, where does legal services in India sit? One of the key driving factors for growth is private equity. And private equity is important for transaction work, private equity is important for disputes work. Given where India is today, and if India wants to drive further investments into India, what do you think should be done, and where do you see this going as far as arbitration is concerned?
So I'd say a significant chunk of the private equity activity is in the middle markets. And to my mind, obviously a lot of disputes come out of private equity investment. To my mind, the biggest area of disputes comes from managing rapid growth and risk. Obviously, investors want returns quickly, and sometimes founders or management take shortcuts. That leads to disputes. Likewise, it can be the other way around. It's the founders that they have a certain vision for the company, and they find investors coming in and saying, you need to comply with this, that, and the other, to be quite frustrating and annoying, and they want to take shortcuts. So I'd say that's where the disputes come from generally, in the private equity area. The other problem is obviously middle market. The companies, smaller mid-level companies, don't have very robust legal compliance teams, and again, leads to shortcuts. I'd say it's really the companies or themselves that can do things to begin with to avoid disputes. That includes clear and well-defined contractual agreements. So when you sign your SHA or whatever your base transaction document is, most likely the SHA, make sure that it has very clear roles, defined rights and obligations, explains exactly exit strategies, valuation metrics, etc. Otherwise, not good for you, but confidentiality, non-compete clauses, etc. Have regular, transparent communication between investors and founders. Give investors updates regularly. Be aligned. They should be aligned so that it's not like the investors going off and wanting returns, which is unrealistic. It's not like the founders having this vision, which is unrealistic. So they should be aligned. corporate governance obviously has come into the forefront with some famous disputes recently. So that's another thing that people need to focus on in internal regulatory compliance. Also extremely important to avoid disputes. Exit strategy, obviously a lot of disputes arise when investors are trying to exit. So, know from the beginning what you want, how you want to exit, what the valuation will be, et cetera, et cetera. I can go on, obviously. Dispute resolution, your clause should be clear. What do you want to do? Litigation, arbitration. Obviously, I will say arbitration. I think it's the quicker, easier method. I would still maybe sometimes say arbitration not seated in India currently, or if it is seated in India, I feel like we always are going around blaming the courts, judiciary, saying, oh, there's too much judicial intervention, et cetera, which there is sometimes, but let's admit it, the courts have changed their attitude significantly over the past 10 years. There has been a sea change in that, but personally, it can't be only the courts, and that's picking up on the last question that you also asked. It can't only be the courts that are changing their attitude. It's the parties and the lawyers that also need to change their attitude. Parties need to stop wanting to delay matters. Lawyers need to stop advising, oh yeah, okay, we'll file this petition, section 9, section 11, section, so-and-so, 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 and then, you can delay your matter by 5 years, 10 years, enforcement by however long. So there has to be a change in everybody's attitude. We can't only be saying, oh, the court. The court has changed and is changing, but we also need to change. So that's another thing that's a... I feel like I've lost what your main question was, but that was my take on private equity disputes.
No, thank you. No, that's really helpful. But, Vikram, can you throw light from a Singapore perspective? I think everybody in this room would have experienced, those of us who do India work, some sort of a Singapore-seated dispute involving private equity. What are the lessons from a private equity standpoint, from a Singapore context, and what do you think needs to be done in India, if at all, to make it more easy to arbitrate?
I'm always very careful about preaching or saying that what Singapore is doing is right and will work elsewhere. But certainly in Singapore, I mentioned a lot of my work does come from India-related parties. Plenty of that also involve JV shareholder disputes. Now, for most of the disputes that I deal with, there will be assets outside of India, so it's not such a big issue to enforce and so on. It's typically one Indian party and one non-Indian party, and they pick Singapore as a neutral venue. But just from feedback I've heard from parties that do want to invest directly in India, and I'll keep it simple. Maybe just 3 things, right? The first is foreign exchange. So I think some parties say India has a lot of growth, but if a foreign investor were to invest, it's quite difficult to take the proceeds out, right? And I mean, RBI has quite a lot of requirements, and there are probably good reasons for this, but certainly, if India wants to welcome more foreign investment, I think making it easy to get returns out will be one important consideration. The second is, and certainly Singapore companies and many companies outside India will have difficulty navigating the many levels of the legal system. So you can have an agreement to invest in a state with the state government. If the state government changes, that agreement may suddenly go on hold, right? Or priorities may change. Federal government agreements may not necessarily be adequate if you're investing at a municipal level. So if there is some way to make it easier to invest, or some kind of protection that can be given to investors against these kinds of political uncertainties, I think that would help as well. And the third is, I think, something that others have mentioned as well, opening up the legal market. 40 years ago, Singapore had this discussion, right, whether we should allow foreign lawyers to come in. And we have, while, of course, keeping Singapore bar open. One of the big differences that has made is, you see, many foreign investors like agreements governed by their own laws. So we have, Japanese law firms, Norwegian law firms, plenty of English and American law firms. And I don't feel any of them are eating our lunch, right? But what they're doing is they're bringing in American companies, Norwegian companies, Japanese companies, with a law that they are familiar with. So it's a different way of looking at things. So, basically, lawyers, we're not driving this for ourselves, but rather facilitating the flow of capital. So, yeah, those are the three main things.
Thank you. Sudhanshu, do you have any comments on this question?
Yeah, so one substantive comment, which is based on my experience of what I'm seeing in London. I'm seeing generally disputes concerning investments that are coming out of India into the UK courts or arbitration, but which often there's a pattern that they're now being routed through Dubai in different ways and for different commercial reasons. It might be the family office is relocated there, or there might be other reasons. The first point I want to make is, from the perspective of the UK lawyer, it's essential to understand exactly what's going on from a commercial perspective and why all of that's happened, because it may impact for questions such as jurisdiction, applicable law, issues of disclosure, and so on. So that's just a substantive comment. And also I wanted to make just a practical comment, and this is much more general about experience of dealing with clients from India. And my point is this, UK lawyers dealing with commercial clients from India should not assume that just because India is a common law jurisdiction, indeed a sophisticated common law jurisdiction, just because your client may be sophisticated with its own general counsel, you must not assume that that client understands the idiosyncrasies of UK litigation. In particular, in the UK, whenever you sign off on a pleading, whether it's a claim or a defense, you have to sign a statement of truth saying in terms the client believes the facts alleged in this document are true, and the claimant recognizes that it is liable for contempt of court if that turns out not to be the case. I've had too many experiences with clients from India. This is not a criticism of Indian clients, it's just the way things are done in the UK, where you're trying to get to the bottom of what happened here. And the answer is not, this is what happened. The answer is, well, what could have happened is. And that's very, very different. And it can have very profound consequences if there's a misunderstanding about the nature of your duties to the court. There's similar points that arise in the context of witness statements and disclosure, the very strict duties around statements of truth.
Priyanka, you raised your hand. Quick one.
Yeah, I think, very quickly, I think one of the key takeaways for me in the last 2 years in PE disputes is perhaps to be more aware of the conflict of law issues that really arise, particularly in the India-Singapore space. Because what's happening with us in the Shadi.com matter, the Westbridge Anupam Mittal matter, is really is your quintessential a conflict of law issue and an arbitration versus the Indian courts or tribunals. Because the position in India today is the law of the seat governs the law of the arbitration agreement. And issues of mismanagement and oppression are not necessarily arbitrable under Indian law. However, in Singapore, thanks to the Anupam Mittal matter now, the law governing the arbitration agreement follows the substantive law of the contract. However, issues of mismanagement and oppression are arbitrable under Singapore law. So in the event you want issues of mismanagement and oppression to be arbitrated in an arbitration seated in Singapore, it would be important for the draftsman to identify upfront what should be the law governing the arbitration agreement.
Thank you. I was told by Niti I can go on to 10 past the hour. So I'm just seeking your express permission. Thank you. We have a fun segment coming up. And I want to show you a chart before the fun segment starts. Look at the bottom two, or you can look at the three charts from the right-hand corner. That's the share of cash transaction reducing rapidly. We all know what UPI has done to India, right? In terms of cash transaction, that's reduced. You can go buy, vegetables from the sabjiwala, just flashing the phone. That's just unbelievable. And then look at the mobile connections. We have 1.2 billion, I think, today. 1.2 billion mobile connections, more than 900 million internet connections. And these are unprecedented in terms of size and scale. The number of financial transactions that happens online real time is probably 3 or 4 times than that of China, and 50% of the global transactions happen through India in real time as far as online transaction is concerned. So India just dominates the space. Now this leads to the question of IP and its importance in our context, because that is really important to facilitate trade. How many of you have heard about Squid Games? Okay. How many of you have heard about this case Shah versus Netflix? Okay, this is going to be interesting then, Shreya. Over to you as to where you see IP disputes, and you need to really talk about Squid Games as well.
Thanks for giving me the lead on this question. I spent an inordinately long amount of time going in the Reddit deep hole of Shah versus Netflix and Squid Games versus the alleged movie that it is copied from. So I'll touch upon that. But coming to your question, trend in new age IP disputes, and I know you mentioned OTT, movies, music, but I also will touch a little bit about metaverse, a concept that was alien to me until a few months ago, but is very interesting. So coming to OTT, India has about 40 or more than 40 OTT platforms today. The OTT industry is expected to reach a value of $12.5 billion US by 2030. And in comparison, just in 2021, which is just a year after the COVID boom in OTT, the market was US 1.5 billion. So it's really an increase in about 12 billion in about 9 years. So this is on the back of factors which Karthik mentioned, such as better networks, digital connectivity, smartphones, etc. And there are broadly 4 buckets of disputes in the OTT and movie space that we foresee. So one is, of course, contractual disputes, which is breach of contracts relating to IP rights, right? So typically in the OTT space, the kind of contracts you see are between the production house, so say, Netflix producing its content, as well as a broadcaster for creation, licensing, and distribution of that content. As you all know, Netflix, for example, is not just a producer of its content, it also hosts a lot of content produced by other producers. So there are contracts in that sphere as well. And these disputes can be, your classic contractual scope of work disputes. So, for example, if there's a license agreement to license rights in relation to certain content to a third party, then does that license include the power to sub-license it? Those kinds of disputes which, you see in any IP contract. The second kind of dispute is infringement of IP rights, and that's where the Shah versus Netflix case is important, because that's about whether or not you have suffered a breach of copyright or trademark rights because somebody else has copied the way in which you expressed your idea. And I want to make that distinction clear, because just in the copyright world, merely copying an idea is not a breach of copyright. It's copying the expression of that idea, which is a breach of copyright. So coming a little bit into Shah versus Netflix. Now, this is effectively really a dispute in New York courts, and it's still pending, so we'll see how the resolution goes. But Netflix has Netflix has a show known as Squid Games, and I think some of you may have seen it, some of you may have heard about it. It's really a concept where there are people competing in a certain game where they pay with their lives, and it's for the entertainment of a whole class of people above for whom it is entertainment. So a little bit like your Hunger Games idea, which is expressed a bit differently in Squid Games. But really, it's not about Hunger Games versus Squid Games. The question here is whether it's a copy of a movie known as Luck, which was released in the Indian movie industry around, I think, 2008 or 2009, which is the same year in which the creator of Squid Games has said he was developing Squid Games. So that's actually the commonality of the year. Again, anything you say in the media many years ago remains on Twitter and media. So remember, you can go back on those statements. So it's an infringement suit for copyrights filed by a Soham Shah, who produced the Luck movie in the U.S. District Court for Southern District of New York against Netflix. This was filed just a few days ago on September 13th, 2024. I'd suggest I won't suggest going down the deep Reddit deep hole that I did, but I think a few news articles will give you the idea of what was the plot of Luck. in my view, just as a layman person, it does seem that they were similar. That said, of course, there are, as I said, it's not about the idea being similar, it's the expression of the idea being similar, so we'll see how the courts decided. Another dispute on a similar line was between Sun TV and Amazon, where Sun TV sought a permanent injunction with respect to its copyrighted content in 28 movies, which were exhibited by Amazon on its OTT platform. The Madras High Court had granted an interim injunction on the basis that Sun TV had acquired these rights from the producer who owned the first copyright over the film, and therefore Sun TV can be expected to exploit all of those rights without infringement by a different entity, which is Amazon. So that's sort of your dispute in the copyright infringement space. The third kind of dispute would be establishing the validity on ownership of IP, and I'll touch upon this a bit further, but these are the kinds of disputes which are not arbitrable under Indian law. And the fourth is intermediary liability, where you can sue an OTT platform such as Netflix or Amazon for breach of IP rights on its platform by a third party. And why is this relevant? Because in 2021, the the information technology rules in relation to intermediary liability of OTT platforms came out. And under those rules, there's a requirement that an intermediary will act in due diligence and will not publish any content which infringes patent, trademark, copyrights, or other proprietary rights. If it does, there's a whole grievance mechanism where you can file a complaint against the OTT platform before a grievance officer, and then that's appealed to an appellate mechanism. So that's really about the kind of disputes you see in the OTT sector. Now, coming very briefly to metaverse. Again, I'm not sure how many people are very familiar with metaverse, but to those like me who are not, it's a digital virtual world where individuals can create character avatars and then play them on a virtual platform where various kinds of simulation experiences can be created. So the concept of metaverse, surprisingly, is not new. It's been in existence since the 1990s. Really, why it has come up in the last few years is because of NFTs, which are non-fungible tokens, and them being used as assets to do business. And that's actually led to a whole host of legal issues. So again, what are the kind of disputes you can see in metaverse? One is, of course, protecting your own IP in metaverse. So recently, Nike has filed applications to register its trademark for goods and services being provided in metaverse. And there questions arise, for example, that whether license agreements, say Nike's own license agreement, for online advertising on the internet, does that extend to metaverse or not? So those are the kinds of questions which we are seeing. The second is just ascertaining jurisdiction in metaverse. So some agreements have jurisdiction clauses, some don't. And then the question arises really, where is metaverse located? In which country's jurisdiction is metaverse located? Or does it extend to all countries? So that's sort of another kind of question that's coming up in a few cases. The third is right of publicity. These avatars resemble real life people, right? I could have an avatar on metaverse, and likewise you can create these avatars for celebrities. So such use without proper authority of the celebrity could result in financial and reputational repercussions, and that's also a kind of dispute we are seeing in some cases. And lastly is intermediary liability. So, for example, the Indian Music Industry Federation, which includes your T-Series, Super Cassettes, etc., Sony Music, they want metaverse operators to be held liable when the IP of creators and users is infringed on metaverse. So it's about whether or not you can, for example, play their music on metaverse without having the appropriate rights. Very interesting stuff, and I'd strongly, as I said, suggest not going down that Reddit deep hole. But very briefly, what are the kinds of trends you see from an Indian perspective here? And I just wanted to recap how Indian law is for IP disputes. So, of course, different countries have taken different views on whether IP disputes are arbitrable or not. Countries like Australia, Japan, Germany, Canada have a very pro-arbitrable approach to all IP disputes. And of course, we are here, all of you must have heard about the World Intellectual Property Organization, WIPO, which is a specific organization for arbitrating IP disputes. ICC also has a specific sort of mechanism for IP disputes. By contrast, in India, we've seen a bit of flip-flop on whether these disputes are arbitrable, but the position now seems to be as follows, which is that disputes in relation to rights which are in personam, so your typical contracts in relation to licensing of IP rights or even copyright infringement, all of those are arbitrable, but disputes which are in relation to in rem rights, meaning rights against the public at large or granted by the state are not arbitrable. That's coming back to the point I made earlier that if it's about your legality or validity of a patent, those disputes are not going to go before an arbitrator. Those will go before the relevant tribunal under the Patents Act. And just finally, just some considerations to bear in mind when you want to pick between arbitration or courts for your contracts in relation to IP. Just 2-3 things which are sort of, which we don't think about so deeply but are relevant for IP. So one is that the very sensitive nature of many IP disputes which involve trade secrets, etc., arbitration can give you the necessary confidentiality protections to protect those. Second is having an expert decide your cases. Very often, if you choose court mechanisms, the judges are not that experienced in very technical IP-related issues, so you can pick specific experts, especially those on WIPO panels for your IP disputes. And the third is just cross-border enforcement, because so much of IP is cross-border. It's not just about your IP rights within this country, but issues relate to your IP rights globally. And therefore, cross-border mechanism and enforcement is always easier with arbitral awards as opposed to court judgments. And that's something to keep in mind when picking your forum selection.
Thank you, Shreya. You've wrapped it up really helpfully. So I'll just conclude the section with some comments. We heard where India sits as far as the geopolitical global macroeconomic canvas is concerned. We heard from Vikram why global trade is very important. We heard from Sudhanshu in light of global trade why BIT is important. It's a double-edged sword. It's not just shying away from BIT because India will be scrutinized, but it also protects Indian investors, and therefore it's important when the negotiations take place. Then we heard from Priyanka in the context of global trade where India sits as far as legal services market is concerned, what needs to be done there. Quickly we moved on to private equity and what it means for disputes in India, and finally concluded beautifully with Shreya's comments on IP disputes and where India is seeing activity in that space. That is amazing for an expert witness on quantum damages to cover without speaking a word about valuation and damages. Thank you very much. But if there's any question in 2-3 minutes, if Neeti allows, from the audience. She's nodded her head, but one question we can take, I think, Neeti. Okay, questions over coffee. You never negotiate with Neeti. Okay, thank you, Neeti. Thanks, everyone.
We'll now be breaking for a very short coffee break, and we'll start with the next session at 10:30 a.m. sharp. And you're always welcome to bring your coffees in the room. Thank you.